Order in the court.
He wants you to show up with
We think we're starting.
pink notebook in your hand.
Okay. Well, as usual, all computers hate all people, and but we finally got our act together, or maybe the computers got their act together, and so now we're starting. I'm the judge today, so if anybody has any questions, if I'm really a judge, I probably won't answer them. Okay, I'll deflect your question, but maybe I will answer it. Okay. Anyway, the purpose we have today is we're going to talk about procedure and forms, and let's see. You're threatening me. Okay, so we'll go to the website here, and we go to the old website. I created the new website as well as the old one, but the old one's the one I'm more familiar with. So even though I created them, and so you click on Start Here, and then you click Start Here again, and this gets you to the foundation page. And this is the central thing. Yesterday we interrupted this process because we had a pretty good guest that came on and gave us a lot of information about what was going on behind the scenes that they normally don't want us to know about. So now I'm going to try and pick up where we left off. And so the first thing I want to do is explain the wig. Okay, you notice that when you see movies and so forth of the nobility in formal session, or even in modern times, in England they wear white wigs. And the reason is because many years ago, it was a popular thing that if you had a competition or somebody was in the way of your career, you got them to eat an arsenic-filled sandwich. And that got rid of the problem. However, somebody had discovered that if you eat a little bit of arsenic each day, you could build up your resistance. In fact, there's one fellow, his name was Rasputin, in Russia, and they tried to kill him. He survived several attempts where they actually injured him, but he still survived. Eventually, they threw him into the river and he drowned. But he had survived the arsenic. He had built up his immunity. But a side effect of eating arsenic is that your hair turns white. So when people were no longer dying as easily from arsenic, then it was no longer popular. However, when they quit eating arsenic, then their hair returned to normal color. And so by that time, it was so embedded that the blue bloods, that's the nobility, always had white hair, that they then started wearing wigs during all of the formal proceedings. However, wigs are a little bit uncomfortable. So I'm going to take this one off. I'm giving up my hallowed position as judge. But as long as we're talking about a hallowed position, there are several officers in the court. And you have the judge, who normally is the traffic director. He gets to tell people, when they get to speak. But you have other officers, for example, the attorneys. Those are significant officers of the court. And traditionally, their job, regardless of which side they are on, their job is to be truth seekers. Well, that obviously doesn't really work out that way, but that's the theory. Other officers are the clerk of the court, the marshal, and we have one more officer that you don't see too much anymore, you see them in action, but you don't see them in uniform. And but they're there. But in olden times, they actually had a uniform. And so I'm going to put mine on. It was the court jester. So the court jester entertained the nobility during breaks and so forth. So that actually was an officer of the court. Okay, enough of that. So, say again. Where did I get the hat? Well, over the years, every year, right along about October, Halloween came along. And I would occasionally go into these Halloween stores and they'd have a sale on something, or they'd have something in stock that appealed. And so over time, I accumulated various officers' hats. So, you know, I've got my sovereign crown, and I've got my judge's hairdo, and court jester, and I've got some other hats too that I brought, but I haven't seen occasion to use them. One of them, of course, is when you're not in your sovereign capacity, you're one of the people, okay, of the United States. So I got that, and it's kind of fun. You do have problems sometimes in court, and so when you challenge the judge too much, they seem to react. So have to go to the other supply store here. And judges or attorneys sometimes become infantile. So I naturally brought along a symbol that represents that. So just as the sovereign has his scepter, to his sign of authority, you also have this, which they don't carry, but you know it's there in their minds. Okay? And then sometimes, if you're really effective, you can really upset the judge. And at that time, he becomes unintelligible. This is what he sounds like, you know, and finally calms down. And we have that. Court can actually be fun. The thing that makes it fun is when you know you're in charge. Okay, you're the decision maker in a court of record. So I'm going to kind of reiterate a little bit of what was yesterday. So we start off with just exactly what is a court. And actually, a court, there's a legal definition, and then there's the practical definition. So here we go. The practical definition is that a court is a stage upon which the sovereign conducts his show, so as to satisfy the rest of the world that his decision is a good one. Now, this was very important. You remember, I said that we had the combination of three different systems of law. We had the Republic of Rome. They created the civil law. And that's where they pass the rules, and then the rules may or not apply depending on the praetor, who was an office who kind of stood between the government and the people. Then you had the barbarians who conquered Rome, and their concept is that power came from the top, and that the king was there by the grace of God, by divine providence. And then you had the what were they called now? I've got a mental block here. anyway, the northern people that came in from the north and conquered England, and that part of England came under their control, and they were the source of the Vikings. That's what it. It was the Vikings became the source of the idea that you have a jury trial, and but the court is like at that time, depending on the type of king you had. Some kings were really benevolent. Other kings were very dictatorial and had absolute power. And of course, kings loved the idea of being there by divine providence because they could do no wrong. If they did something that was, you would think was against the law, then they simply changed the law for the moment. So when they had the jury system, which kind of stood in the way of the king, the king had a good solution from his point of view. If the jury decided somebody was innocent, then the jury got to go to jail, and they served the appropriate sentence, because after all, the king is never wrong, because he's there by divine providence, and he speaks, God speaks through the king. See? So it was a handy thing for the king. So anyway, this is the practical definition. A court is a stage. And by the way, you remember that yesterday, that the courts get registered with Dun & Bradstreet, and they're registered as theaters. So it really is a show. And you kind of have to take that into consideration. So when you put on your show, you want it to be pretty convincing too. And so that's the practical definition. The legal definition of a court is the person and the suit of the sovereign. Okay? The sovereign in his own person. You know, you hear a lot about how, the person, if you say you're a person, you're subject to the government and all that. The reality is that the word person is a context-sensitive word. Depends on what the context is that you're using it. So here we're saying the person and the suit of the sovereign is the sovereign in his own person files a suit against somebody, and that creates the court, because the court is not a place. The court is a concept. It's what we call a legal fiction. A legal fiction means that, you know, you can't see a court, but we accept the idea that if the sovereign files a lawsuit, that created a court, which we all exist in our minds. Okay? And of course, it has very real consequences. So that leads us to the next item, which is a court of record. Okay? And I can see that I got to reduce that a little bit. So in the court of record, I want to remind you that a court of record has 4 absolute requirements that it has to be if it's going to be a court of record. And the court of record, there are many different kinds of courts, but the court that you want, when you're going after somebody, you're doing the suing, you want a court of record. And here's why. Reason number 4, the tribunal is independent of the magistrate. So in a court, you have the sovereign of court who's sitting on the bench, and not the judge, okay? The plaintiff is actually the sovereign, okay? But you wear different hats at different times. Just like in a play, if you're an actor who's playing multiple parts, the part you play depends on the moment that you're involved in. So when you are the plaintiff, then you're petitioning the court. Yeah, it's your court, but you're still asking the court for whatever you're asking for. If you have a lawsuit, you're asking to extract something from the defendant. If you're making a motion, you're asking the court to award whatever you wanted to do, issue an order or whatever. So when you're not the plaintiff, you're wearing the tribunal hat. The tribunal, that's a word from the Latin. It does not mean three. A lot of people think tri means three. It doesn't in this case. Tribunal means the body that's making the decision. So in the case of, put your mind back to the 15th century, the king is the one who does the judgments. He's sitting on his throne. He's hearing the case. He has judges, but the judges are actually counselors at that point. They have no authority to make the decision as long as the king is there. So when you're in court, you have your sovereign presence. Of course, if you're playing the part of a plaintiff, you do that accordingly. But first and foremost, you're always in your sovereign capacity. All you have to do is choose to exercise it at the right time. Now, theoretically, what I said is pretty much theory, okay? But there's a practical side. And the practical side is that when you make your decisions, how do you get people to follow your decisions? So typically, if your rights are involved, you're suing government in one form or another. Well, after you win your lawsuit, you have to come around back to these same people or the same type of people to enforce your judgment. So it's very important to learn diplomacy. You can't just blast in and say, okay, I'm in charge now, which in theory you are, but in actual practice, people might say, I don't wanna. And if they don't wanna, you don't have the power physically to force them to wanna. So you have to take that into consideration. And as I mentioned before, I always try to cultivate a good social relationship with the clerks and attorneys and whatever. And I always tell them my warm-up joke, which is about the parking. And that helps to warm things up. And I get a lot of cooperation sometimes. You know, the clerks are not allowed to give you instructions or to guide. They can't tell you what to do. Okay, can't give you advice is what they always say. And what I do when I go to a clerk, I will say, what do you require? They can tell you what they require, but they can't tell you what to do. Okay, so that's just a little. That's part of your diplomacy. You've got to word things correctly. In the court system, it's very important to say things in the right way. And so there are courses available on the internet teaching protocol. And you should take advantage of those. You cannot be an angry person, because anger, to the bureaucrats, anger means you're out of control. And in a sense you are, because when you're angry, your mind becomes focused, narrows down, and you miss the opportunities to win, to succeed. So, and I gave the example yesterday of how if you get a new car, even a new used car, suddenly you're seeing that same kind of car everywhere. It's because your brain got programmed to where you're more aware of that specific point. Well, anger tends to shut that down. So you want to be able to be generally a happy person. It builds health anyway. It's better for you health-wise. But you want to be a happy person so you can be more sensitive to what's going on in the world around you. And I'm not talking about Pollyannish type of happiness, but you should be generally feeling in good nature. And it is an established fact that anger is actually a habit. Sure, events can come along to upset you, but the person who's always anger, or always on the edge of anger, that's a habit that they have, and you need to break it. And as I explained before, when I was 18, I decided to break that habit, and it took about 5 years to make significant progress. Didn't mean I made complete progress. I continued to learn as the years passed by, but you can't be an angry person. So anyhow, so in a court of record, the tribunal is independent of the magistrate. So the magistrate's basically in a court of record is the chief clerk, and his job is ministerial. A ministerial judge, which is what he is, administers the process, and that's all he can do. We have rules that say who gets to speak when. Okay, so the plaintiff typically talks first, the defendant talks second, and then the plaintiff gets to reply to the answer. And that's part of your normal process. And the judge, if you're actually in a hearing, the judge rightfully is going to say, okay, it's your turn, or he'll call the case and the plaintiff steps up and talks first. So, but the judge is not allowed in a court of record. He is not allowed to make any decisions. In a court of record, the tribunal makes the final decisions. Well, if you're in court and you're looking at the judge, he's looking at you as if you were a plaintiff. You cannot make decisions at that point in time for a couple of reasons. One of the reasons, the biggest reason, is the judge has to preserve his image with the courtiers that have attended the court. For example, the attorneys. He has to work with these attorneys every day. And so I do not do anything in court, if I can avoid it, to embarrass the judge in front of the attorneys. And if the judge does something stupid, or he's mean or whatever, the only thing I ever do in court is I say, I object. Okay? You don't have to yell at him. You just simply say you object in a nice, quiet voice. Okay? And that's perfectly normal process. You'll never be given contempt of court from the judge if that's all you do. Now, the judge might ask you, well, why do you object? And then I would say, well, it's not my wish. And you'll hear the snickering in the background from the attorneys. Okay, they do snicker because they think you're being stupid. But the fact of the matter is that when you are the sovereign, the king or the queen of the court, then your wish is their command. And that's a 1,000-year-old tradition. Okay? Why is the wish a command? The reason is this. Kings are human. Okay? The courtiers are human. If a king is an obnoxious person, he will basically take a risk at being killed because somebody else might want to be king. Okay? And he might lose his support. So when a king exercises a wish, he's softening the order. Everybody understands it's an order, but it softens the sound of it. That's basically protocol. Okay? So in court, I'll say it's my wish, whatever. It's my wish that we don't do this, or my wish is that we do something. And the judge most likely will say at that point, well, you're overruled. Okay? And if you have a chance to speak, you say, well, for the record, that is my wish. And then he might say, well, that's noted. And that's the complete sequence of words. It doesn't always happen that way. The judge may decide not to let you speak anymore. At least not on that point. If you're in the process of making a speech, you could maybe pick up on the rest of your talk. But at least you made your point, which is that you object. And that's all that's required. Because when you leave the court, the first place you head with a fresh memory of the situation is you head for your typewriter and you type up a writ of error canceling the judge's decision. What you do is you rescind it. That means it's no good from the beginning, okay? Never was a good one. I've actually taken the written order of the judge and in big letters going from corner to corner on the paper, rescinded in red letters. And I attach that to the order where I'm rescinding it, okay? And by the way, on my order, I also have what's called an order to show cause. Whenever you issue an order that's fresh on its own, there's always the possibility that you're wrong. So the order to show cause gives an opportunity to the participants to tell you that you're wrong, okay? And sometimes they make sense. I know one time I issued an order and I was actually citing a code. And the opposing attorney came back and in his objection, he said that there is no such code. And I looked it up again, and what had happened is that they had taken that out of the codes. I was looking at a code that was too old, and he was right. So I went ahead and backed down, revised the order so that it made sense. It didn't change the outcome, but it certainly settled that little point. So I always include an order to show cause with every order that I issue. Now, that's actually called, I think it's called a peremptory order. Well, regardless of the big words, the point is that you're issuing an order spontaneously from you. Normally, to get an order, somebody has to make a request to the court. That's called a motion. And then normally the opposition has a chance to answer. And then normally you have an opportunity, not required, but you have an opportunity to reply to the answer. So when you do that, the next step is to make a decision. Those are the basic 3 papers that get filed. And so you make a decision, and that's fine. I include an order to show cause just in case I might have made a mistake, okay? So other than that one opportunity, I've never had anybody ever come back showing cause. They never filed a paper or anything. It's interesting. What they do is they try to ignore you. What are you going to do if they don't pay any attention to you? Well, that's easy enough. What you do is you issue the order again, okay? And then if they disobey that, then what I do is I fine them for contempt of court. Now, the first fine is for $1. The reason it's $1 is because it's not the money that's important, it's the law, okay? So nobody can say that I'm trying to somehow profit off of them, off of the procedure. And then when I fine them $1, I make it payable to the general fund of the county, okay? So I never get to see the money, which by the way never gets paid, okay? But at least the principle's there. Then and subsequent conflicts with whoever, if they continue to be contemptuous of the court's authority, then what I do is I'll raise the fine, let's say $50 or $100 each time. And each time they might ignore it because, hey, nothing really happened, just another order, So after about a half dozen, then I'll issue a bench warrant for the arrest of the individual. And I give that bench warrant to the sheriff, And the bench warrant itself is an educational document designed to educate the sheriff, because typically the sheriffs don't really know their jobs. They think they're cops. They're actually the top administrator of the county business. But they think they're cops, and sometimes you have to override that by educating them. And so they get the court order, they get a copy of the court order, certified copy, because that way he knows it really is from the court. You get the certified copy from the clerk. When you file your order, you then immediately ask for a certified copy, and then you can serve that. Because otherwise the sheriff would just think it's bogus, because after all, it's not signed by a judge, it's signed by you. Okay, so you have to explain to the sheriff why this is a real court, because he'll think, hey, no judge. I say, you can ignore it. And that happened to me one time where I found that I was in the courthouse, and I located the deputy sheriff his regular job was enforcing court orders. And I gave it to him, and then I checked back a week later, he hadn't done anything, and because he had his doubts as to whether it just didn't make sense to him. And so I conversed with him. He was a very friendly guy. His job was not going out and beating up people. Okay, his job was just really locally administrative. And so we had a nice conversation, and I don't know what he did after that, but what I do know is that about a week later, the judge changed his attitude and issued more reasonable orders, which of course I rescinded. So, but anyway, he was a more reasonable judge after he realized he could have gone to jail. Because what I did in the bench warrant was I made it a real soft, aside from the educational stuff, I made it a soft order. In other words, I'm not trying to put the judge in jail. What I'm trying to do is change his behavior. So I instructed the sheriff to go to the judge and get the judge either in writing or orally promise that henceforth he would obey all court orders. And if he refused to do that, then the sheriff was to take the judge into custody and hold him until he did promise. So it's a very easy thing. Even if the judge is lying, at least he could avoid being arrested. And again, you're not looking for a fight. What you're looking for is control. You want to control these people and get them to do the right thing. Now, I will have to say this, that what I'm talking about works best on the state level. And the reason it works best is because the sheriff is elected. And he isn't necessarily having to pay attention to the judge. If the law says that the judge goes to jail, the judge will go to jail. The sheriff will arrest a judge. Generally, the sheriff does respect the judges. In fact, they're even a little afraid of the judges. But nevertheless, push comes to shove, the sheriff can arrest the judge, okay, if it's in the law. This technique does not work so well in federal courts. And the reason it doesn't is because the marshal, that's what they are on the federal level, the marshal, you kind of think, well, he does the job of a sheriff. But the actual fact is that in the federal court system, the marshal is part of the court. The judge is actually his boss, okay? Or the chief judge is his boss. So he's not as free to buck the judge as a sheriff is on the state level. So getting a little more detail here, here's actual sites, so you know I'm talking about the real thing. We have, for example, we have a bunch of cases here. defining what a court of record is. It says a court of record is one whose acts and judicial proceedings are enrolled or recorded for a perpetual memory and testimony, and which have power to fine or imprison for contempt. They keep a record, and they can fine or imprison for contempt. Now that's a requirement that when you look up a court of record in Black's Law Dictionary, the 5th edition and later, you'll find that requirement stated in there. The other two requirements you won't find in that dictionary. You have to go to an older dictionary, the 4th edition or earlier, and you'll see that a court of record is a judicial tribunal having attributes and exercising functions independently of the person of the magistrate designated generally to hold it. A lot of words, but what we're saying is that the judge is a magistrate and he's not the decision maker. The person, a judicial tribunal, has attributes and exercises those functions independently of the magistrate. So if you go to the California codes, you'll see, I'm scanning down here, section 808 of the penal code in California says the judges of the Supreme Court, the courts of appeal, the superior courts, the municipal courts, and the justice courts, they are all magistrates. So the word judge and the word magistrates are synonyms. They are synonyms. They both mean the same thing. So if the tribunal's independent of the magistrate, then who's the tribunal? And obviously that's the king or the queen. Okay? So a friend of mine was really in depth and big on the idea of sovereignty. And one time he was helping a friend, and he went into court and he delivered to the court a paper which was a notice. It was a notice of sovereign presence. That was something they weren't used to. And he put into it all the logic why it was that now that one of the sovereigns of the state of California was here watching him. And it affected the proceedings. He was quite innovative. I liked him. He one time was conducted out of the IRS offices. They didn't want him around the building. And they told him the reason why is because they didn't have any business with him.
Is he still alive?
Unfortunately, he's very ill and we don't expect him to live. So currently, but a great guy, helped a lot of people, and I guess we all have to go sometime, you know. I'm 85, so I don't know how long I'll be around, you know.
Long time. Long time.
We hope, yes. So anyway, it's very important to keep the first four rules you see here. Not there. I meant to say for what a court of record is. Okay? You got to keep in mind, a court does not have to have a seal. However, you should have a seal. Let me explain contracts. A contract, a normal contract that you're familiar with, you negotiate with somebody to do something or buy something, whatever, and you have that negotiating process. And so if there's a conflict later on, then the courts will kind of weigh the evidence, and whichever way the scale tips, that's the winner. Okay? That's if both sides negotiated the deal. An adhesion contract is a contract which is given to you, offered to you on a take it or leave it basis. And you have to, or they have to cover every single detail, because if they don't cover a detail and a conflict comes up based on that detail, then the contract maker loses automatically. So everything is on the side of the other party if it's not in the contract. And that's why insurance contracts, lease contracts, rental contracts have so much writing in them. It's because if they don't cover a point and it gets to court, they'll lose. So that's what's called an adhesion contract. Now, two people making an agreement to do something, even if it's in writing, if they kind of agree to do something, that's not enforceable in court. What is enforceable in court is where you have the actual signatures, the two people agreeing to do something. If somebody gives you a writing and says, I promise to give you $1,000 next Sunday, that's not enforceable. It's a one-sided contract. You didn't agree to it. Now, the next kind of contract, it's called, what does God say when he makes promises biblically? Another mental block here. Don't we have any biblical people here? Well, look, anyway, a covenant. There you go. Okay, so a covenant in the secular world, not religious, a covenant is a promise, a one-sided promise given to you, but it has a seal. Okay? The seal is what they call the consideration. So we know when the seal is on the document, then you're committed. Now, what does it take to put a seal on a document? All it takes is the word seal, S-E-A-L. Okay? So you have your writing on the page, whatever it is, and then down near the bottom in the signature area, you have the word seal next to the signature. Now it becomes a covenant if it's one-sided. I'll show you an example of a seal. Let's see. Here we go. The seal will have, the one thing that makes a seal unique is it has the word seal on it. Okay? So if you don't have the word seal on it, it's not a seal. Okay? For example, look at the California seal. What does it say on it? It says the Great Seal of California. The word seal is there. That makes it a seal. The word can be by itself as not part of a sentence. It's still seal. Okay? And let's see, where are we here? Say again? Oh, okay. We like jokes.
Yeah, use the microphone, Alan. Alan, use the microphone, so don't make a joke with that on.
So Bill, can I get
Too
this?
much stand up.
A seal?
Okay, don't make a joke. Yeah.
A seal is either a word. or
Yes,
Yes, it can
yeah.
also be a photo.
Well, you have these,
Yes,
like a stamp
yes.
can be a seal.
Okay,
Okay? And in fact, the word stamp, generically used, does not mean a post office stamp. Okay? A stamp is a piece of paper with a glue on the back and you put it on. That's called a stamp.
so you could have a butterfly or.
Yeah,
But
anything.
it has to say seal on it.
Absolutely. But as soon as I get my act together here,
Great seal of honor.
I will show.
Get a picture of the seal, put seal on the seal. And
Yeah.
of it.
I like that.
I'm going to show you a seal. Okay? And
Like an animal.
it's working on it. computer's working on it. It's very labor intensive. But the seal, typically what I put on a seal is, in addition to the word, I'll put my date of birth, because when I was born, that's when I created my court. Okay? And then I have some esoteric things on it, which you will see right now, I think. Here we go. I believe it's right here somewhere. Okay, I guess I'm in the wrong folder. So we will go to I know where I can go to get it. Little dead space here. Go to still learning to type. Keep getting caps. I think there's one there. That's a seal. And just to help out a little, I'll make it bigger. So I'll put my name, I'll put my date of birth, and I'll put some like wisdom, strength, and justice, okay? Some idealistic thing, just to be, make it pretty and put some meaning into it in a way. The only thing that's important is the word seal, okay? And
So you can lie about your birthday? You can lie about your birthday?
well, it does. That's not a requirement.
No, I know.
The only thing that's required is the word seal. I choose to put my birth date on it because that's the day I think I created my court.
But you weren't born in 55.
This is not my seal.
Oh, I see. Oh, this is Robert. It doesn't take no. Okay, never mind.
Yeah, this is just an example.
Okay.
Okay.
So it can be a sticker, it can be wax.
You can put a butterfly on it, I think you mentioned, okay? So, yeah, you can put anything.
Can you write it, or does it have to be like a?
It's anything you want as long as the word seal is there, okay?
You can literally write seal next to it and you're done.
That's right. In fact, I tell you, just to prove it, one time I filed a paper in the court it was the federal court in Las Vegas, okay? And it required a seal, okay, on the part of the court. And so the clerk took a little rubber stamp out, stamped the paper, and it said seal. That was all it was. Just the word seal, rubber stamped, okay? So, but it's very important. The concept of a seal is very important. For the court, it's optional. However, the seal makes a difference to some people. And it's a pretty strong tradition, even though it's optional. So,
What's the difference between a covenant and what's the difference between a covenant and
speak to me. I can't hear you.
what's the difference between a covenant and just the regular contract?
Get it close.
It's just have to scream into it.
You have to yell a little bit.
What's the difference between a covenant and just a regular contract? What is the seal?
Oh, a covenant is a one-sided contract. If I promise to give you $1,000 next Sunday, and I put it in writing, and I sign it, and I seal it, you can sue me for it if I don't deliver. Okay?
If it's not sealed, then it doesn't.
Now, and one-sided contracts do not count in our legal system. But if it's a covenant, meaning it's sealed, in addition to all the other requirements, then yeah, it's enforceable.
Does seal have to be in all caps, or does it matter?
Just need the word seal.
They used to have something called covenants, contracts, CCR, that would be on deeds. So we called it covenants, contracts. and
Yeah.
I can't remember what R stands for. but-
And also mortgages. I think mortgages are one-sided. They're actually covenants. I don't know. I have seen it on real estate papers. I'll say that much, where I looked and I saw, oh, only one signature, but it had said seal. Well, okay, you know.
So we can create our own stamp.
Yeah, you go down to the stationery store. They have a catalog. You can pick out different formats. I always do my own artwork, just like here. I did this sample, and that's good enough.
And
Now-
any color of our choice.
No, it's not color. It's black and white design. Camera ready for the seal maker to take a picture of it. Now, the seal itself, you can have a rubber stamp with your seal, with whatever color ink you choose, but you can also have shiny stamps that are glued on the back. You glue it to the paper, and you take your little machine and you crimp it, and you have a three-dimensional seal. And that seal, by the way, on that kind of a seal where it reflects light, almost like a mirror, beautifully reproduces on a copy machine. You'd be amazed at how well it copies, and yet it's all one color.
And the printer will be able to do that as well.
Say again?
A printing shop will be able to do it like that.
Well, not a print shop, but certainly a seal manufacturer.
Manufacturers, yes,
Right.
sorry, yes.
Sure, print shops, the normal print shop can't make seals, but they can take your order for a seal and then they refer it over to a manufacturer. The seal is quite nice. I suggest that you get, when you do a seal, that you make it over 2 inches in diameter, okay? They have two sizes. I think one is 1 3/4 and the other is 2.1 inches, something like that. Get the larger size. The reason is it's more impressive, okay? And also, another point to remember when you order a seal is you want to have it, the seal has to be right side up when your machine is crimping from the right side of the paper, okay? If you don't say anything, they might assume that you're crimping it from the bottom. Don't do that. You want to put that machine on the right side of the paper, and when you crimp it, the image comes out right side up.
A moment ago, Alan was talking about the CCRs, the Declaration of Covenants, Conditions, and Restrictions. They're usually used in homeowners associations.
Well, this declaration with all those words, I think is a little overkill, because if you have both parties signing the contract, you don't need the word covenant. In fact, it's really just a contract. Well, yeah, it can be a covenant, it gives it a little more credibility, that's all. But yeah. If people do this, they use words that sound very legal and good, but in reality, they're unnecessary. A common word that you got to watch out for is duly. Duly, D-U-L-Y. It was duly ordered to do something, and the word duly means that it satisfies the requirements of both the common law and the equity law. So don't use duly unless that's what you mean. If you're in a court of record going according to common law procedure, I would not use the word duly because I don't want to involve the equity courts. So the last thing on the seal that I put is Dei Gratia. And that means by the grace of God. Okay? There's two forms of that statement depending on whether God is male or female. One I think is Dei Gratia and the other is Dei Gratia. So anytime you use legal language, I suggest that you actually know what the word means that you're using. And if you have any failure of memory or weakness of memory, look it up. I do that all the time when I'm writing papers and I dredge up a fancy word in my mind. I'll go right to Google, or actually I go right to my browser, and where you put in the address, I just type in the word and it comes up with definitions. And I assure myself that I'm using a word correctly.
Then we look at fourth edition of Black's Law.
Well, they don't put the English language in there, they just put English legal language. So you have resources, okay? The 1215.org has several dictionaries in it. We've got Black's Fourth in there, we've got, I think the first edition is in there, and I think we have the fifth edition, I'm not sure, okay? It's either the sixth or seventh edition that's really bad, because in their wisdom, they took out all the case law. So you get a definition and all you're doing is quoting the dictionary, no case law. That really upset the attorneys. In later editions, they put it back in. The attorneys did not like that.
Bill, on Rumble chat, Plead is saying, can your court seal be the same as your house seal?
I don't know what you mean by a house seal.
He's saying he's having his house seal made using, I guess, his family coat of arms and emblems that have significance to him,
Well, like I said, the only thing that's important is the word seal. Anything else is what you want. You can have artwork, you can have, typically the most often form you see is the round form. You can make it square, you can make it triangular. If it has the word seal, it's a seal.
Corporations have, usually they put a gold seal, then they have their, what do you call it when you embossed? Yeah, and then
Well, now, Tony Wu was saying that in his research, the color of the seal made a difference. Okay, I'm not familiar with that. I can't address that question, but it could be that there are things. But remember this. Here's where I kind of makes me smile, you might say. Who's the decider here? Look, we the people are on top of this system. We are the creators of the government. The preamble specifically says, and I'm shortening it a little, but it says, we the people ordain and establish this Constitution for the United States of America. Ordain means we're authorizing it, okay? And establishing means we actually put it on the parchment or on the paper, and so it's by our authority that they can do what they're doing. And you look at California has this very convenient pair of codes where they say the people of this state do not yield their sovereignty to the agency which serve them. Okay? I do not yield my sovereignty. Well, sovereignty means you have no responsibility to higher authority. Not in the secular world.
There's
Okay?
none higher than you. There's no authority higher than you.
You are the highest authority. That's correct. Yes. So, there's all these questions about, is your name uppercase or lowercase? Okay. Did you use red ink or blue ink? Or black ink? In my court, that's not important. And remember, that the decree of the sovereign makes law. I have that case on the website, okay? The decree of the sovereign makes law.
Do you, a really quick question, it's maybe not that important, but you use your birth date, for instance. If you have a family.
Wait a minute, you're putting too much importance on that, okay?
That's why I'm just want to ask this.
No,
So,
no, back off. You're,
okay, no, my question is, so we have a family seal that's very old. Can you put the date when that was established on there? You can put whatever you want, basically.
what did I tell you about the word seal?
That's all that's important.
There you go. Okay? That's it. You put anything you want, okay? This was my choice. I did my research and I kind of decided what I thought would be nice to add to it. So I put in my little philosophy. My latest seal, I have wisdom, strength, beauty, and justice. Okay? The wisdom to contrive, the strength to implement it, and the beauty to adorn it, just make it beautiful, and justice. Okay? Since it's a court process, I use it as my court seal. And by the way, I only put my seal on my orders. I do not put it on my filings anywhere. Okay? That gives you the strength. You remember the kid that cried wolf? You know that story, everybody, I hope? Okay? If you put your seal on everything, it devalues it. They say, oh, here's another paper with a seal on it, No, it's on my orders only. You can put your seal on it, okay? But my policy, my personal choice is to not use a seal except when I mean business. I'm issuing an order and that order must be obeyed. Yes.
Well, I'm an architect.
What?
They give you
Hold on.
I'm an architect and they give you a stamp to stamp your drawings.
Does it say seal on it?
I don't think so. No, it says, but, okay, never mind, it's irrelevant.
And another one of those frivolous questions.
We are just ignorant people.
Well, see, I think your question really demonstrates an important idea. It's really tough to change your perspective, okay? One of the problems we have with clerks, judges, cops, personnel, they have their channels of thinking. And when you try to educate them, they just don't see it. And some of the worst people are attorneys. And I have a personal friend who's really good at his game. But when we talk about common law and the things I do, he thinks I'm bonkers, It doesn't matter if I show him, oh, here's case law and so forth. He just doesn't believe it, okay? So this is the problem of switching gears. You can't switch gears immediately, no matter how logical it is. People are not logical creatures. We're emotional based, okay? So that's what protocol is all about. Protocol is saying the right things for what they understand in order to get accomplish what you want. See?
Also, we have to keep in mind unalienable rights. Not just, one of the people, but unalienable rights. This keeps us
Well,
with the Creator.
the problem there is
Okay.
how many of these oath takers have read the Constitution or the Bill of Rights or the Declaration of Independence? It's really hard to change a person's mind. And I fall into the trap myself. There are times that, I review my writings a lot. Mark Twain had 7 rules for good writing. And I can recite them, every one of them by heart, okay? Quite an accomplishment, I think. So I'm going to quote it to you. The 7 rules by Mark Twain for good writing are: Revise, 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 revise. Okay? That's what you got to do. You do a writing. If you have time, set it aside for a day or two and read it again and revise it. And do it again and revise it. You will find there's crap in there, you know? And just because I've been down the road, believe me, I'm no different. My writings are pretty crappy when I write the first edition. And you have to do it again. So that's a great. Now, if you're under pressure, time pressure, you do the best you can. But anyway, so that's my story about seals, and that you get a seal that is the largest one, and at the same time, you order about 50 of these little stamps for sealing, and that should last you quite a while, because you don't issue that many orders. So I've had my supply of seals. I'm starting to run out, but I think I've had it about 20 years. See, you don't use many seals. And it's really nice, though, when you present it and they look at it and, maybe this is serious or whatever. I don't know. It makes no difference. It's no different than just stamping the word seal on your paper, but still, it's impressive.
Bill, it's different, but for a corporate seal once, I just ordered a JPEG, off some website, and I would just insert that on my corporate paper sometimes.
The seal can be printed, okay, pre-printed, sure. But the seal is the proof of genuineness, okay? Now, in a corporation, you typically have a president, treasurer, and secretary. Those are the three main offices of every corporation. And the secretary is the record keeper. Anytime you want something in the way of documentation, the archivist, the record keeper, is the secretary, okay? So, and if you want it basically certified, the secretary of a corporation can certify that this is a true and correct copy of the corporation records, okay? The secretary is just like the court clerk in the sense that when the clerk says it, it must be true, okay? It gives it that strength of credibility.
So a motion is an order, and the seal can go on the motion, that order.
Not on the motion.
Oh, not on the motion, okay.
In a motion, you're begging the court for a favor, okay? An order is the court saying, this is how it's going to be, Jack, or in your case, Jacqueline, okay? Yeah, an order is just like it says, an order, okay? A motion, a request, a petition, those are all begging the court for a favor.
Okay, so motion is not order.
Not at all.
Bill, the secretary then has really a lot of power. I know Dennis Gray, when he sets people up in a nonprofit unincorporated association, him and his wife set it up, but they resign as president and secretary, and appoint you the secretary, so you're in control of that for asset protection or whatever business you're doing with it from then on. You're just a secretary, so that gives a lot of control, I think, in some entities.
My instinct says to disagree with that.
Meaning you should have a president all the time, or what?
That means I don't know crap, okay?
Yeah.
But my instinct says that that's not true, because you have to have in any organization somebody who has the title of being boss, the decision maker, the brains of the outfit, okay? The secretary is not the brains of the outfit. By its very title, the secretary is a record keeper, okay? An archivist keeps the records of the whatever the organization is, whether it's incorporated or not. So and an organization can exist under the common law, but it's not a trust unless it's a common law trust, okay? And by the way, a common law trust, I haven't been able to see any serious difference between that and any other trust, because you always have the same elements of every trust. You have somebody who's the trustor doing the trusting, okay? You have somebody who's a trustee who's actually managing it, and you have somebody who benefits, okay? And you have a list of duties. What is it that the trustee does for the benefit of the beneficiary? Okay?
Mentioned in the Constitution preamble.
Yeah, the
yesterday.
preamble itself, it has all the elements of a trust in it. Okay? So, every corporation is actually a trust. Okay? Franklin Delano Roosevelt had a reputation as a trust buster. He went in and busted up the oil companies. Okay? They were all corporations. And that's why he was called a trust buster, because he was busting up the corporations, which are all trusts. Whether it's a non-profit corporation, a profit corporation, or some other entity that's incorporated, it's still a trust. So,
some people point out that that's actually right out of the biblical line of, was it Isaiah 33:22, for the Lord is our judge, the Lord is our lawgiver, the Lord is our king. So you get the king, the lawgiver, the Congress, and then judicial system being the judge, right?
and that's Old Testament, right?
Yeah.
Okay. In other words, in the Old Testament, there was no separation of church and state. Okay? The church and the state were pretty much connected, okay, solidly. So in our modern times, at least in the United States, we've separated the two. And because there's simply been too much done that's bad, because the church acquired the physical power to enforce what it wanted. And of course, with definite knowledge on the part of the religious people that they were right and everybody was wrong, sometimes you got burned at the stake, especially during the Inquisition. So I don't accept the idea of a unitary type of government anymore. Okay.
Too.
Yes, you want to say something?
I just agreed with you.
You disagree with me? Okay.
No, I agreed with
Oh,
you.
well, thank you. Well, it's a problem, you know, I mean, every attempt that humanity has made to create a system of justice, fair play, and so forth has failed. The reason it failed is that there is no such thing as a perfect system, and somehow the bad guys eventually figure it out. Might take several generations, but they figure it out and they destroy it. And the United States is no exception, you know. We have a pretty good constitution, I think, but it's not all being enforced. Let me give you a good example. I have a pretty good faith that everybody is familiar with the concept of marriage. Okay? Two people get married. Now, I have an article about common law marriages on my website. But back in the time of Martin Luther, who was a Catholic priest before he broke away, but he put his 99 points of his questions about the practices of the Catholic Church. And the Catholic Church wasn't responsive, apparently, at least the Pope wasn't. And so they ignored what he nailed on the door, and so he split. Okay? Well, at that time, he was asked, and the Pope was asked, is marriage, important? What was the interest of the church in marriage? And both of them said, we have no interest in it. Okay? Yeah, it's a concept. People do get married. Humans have a tendency to pair up. But there was no church interest in it. And the king also said, no, we don't have any interest. People get married. Yeah, obviously. But we have no interest in that process. Then we had this United States came into existence. And we had this little problem. It turned out that some white people in the South were cohabitating with black people. And so that was illegal. They weren't married. They made it illegal. Well, it turned out that they were cohabitating anyway. And that process of two different races cohabitating was called miscegenation. Okay, that's the word. Miscegenation means unlike races getting together. So they had this problem that although it was illegal for miscegenation, people were living together anyway. Okay? So this created a political problem. What do you do about this? Okay, well, they came up with a solution. They said, well, let's have them buy a license. That way, the miscegenation laws would still be in place, but a license, the technical definition of a license, is permission from the state to do something that otherwise would be illegal. That's what a license is. So, you have a business license, it'd be illegal to be in business unless you have the license. Then you can do it. Okay, you got a driver's license, it's illegal to engage in commerce unless you got a license. Okay? So they granted marriage license to people. Well, that kind of solved the problem because they could always say, oh yeah, it's illegal for them to cohabitate. But if they're married, well, they paid their fee and it's okay. And so the white opposition was pretty well subdued by that little tactic. Well, that turned out into a moneymaker, and so all the states jumped in on that one, okay? But if you look in the old law dictionary, you look up marriage, and it says it's permission for cohabitation, for miscegenation, okay?
So miscegenation is just two different races,
Pardon?
Miscegenation, the definition of that again?
The echoes are
Then what's the definition of miscegenation?
two races, two people from two different races marrying, yeah, or not marrying, but cohabitating, yeah. So, anyway, now this is, in my opinion, this is a perfect example of the Constitution not being followed and getting results. Because what happened next? What happened next is that gay people said, well, wait a minute. You got all these people who get married are getting special tax privileges. Well, if you read the Constitution, it says that the state cannot grant a title of nobility. A title of nobility is a permission from the state to get special privileges, not available to others. Okay? So by violating the Constitution, creating this marriage license, they now created a problem that naturally would arise from the state giving special privileges. It isn't necessarily marriage, it could be other things they have special privileges for. A driver's license is different. We, the people, authorize the government to regulate commerce. And driving, if you're driving, that means that you're using the public highways for profit, okay? If you're just traveling as an individual, then that's not commerce, and that's okay. But you have to have a license to do business on the highways, okay? People who had jobs and they they had a shared carpool van. No driver's license was required for that. The cases have already been decided back in the 1920s, okay? However, driver's licenses is such a wonderful deal for the state. Not only is it profitable, but it's also a means of control and a means of tracking. So they've taught everybody, you gotta have a driver's license if you're gonna drive, right? And that's a true statement, okay? Because the word drive is a commercial statement. So they can regulate it. So anyway, my point is the Constitution's not being followed, and that's an example of it. Yeah, you're gonna say something?
Online, they're wondering if you can briefly compare something being sealed to yesterday's discussion on having notarized.
A notary is officially a state officer, okay? He's a credible witness. So when you go to a notary and you identify yourself and you sign a document, the principal job of a notary is to make sure you are who you say you are, and that is your signature. And that's the entire job of the notary, okay? So the other job, the notary actually has several jobs, but these are the two principal ones. The other job is to make what are called jurats. But it's effectively pretty much the same as an acknowledgement. I first described to you an acknowledgement. A jurat means that the individual goes to the notary and he says, the information on this paper is true. And he swears to it. This is a true copy or true content, whatever. The notary is the officer that he's swearing to. And so when he does that, and then he signs it, and he has to sign it in front of the notary, okay? And he's properly identified by the notary. Now, that completes the task. Okay, the notary puts it in the official record, and that's done. Okay? Again, a jurat is basically the notary saying two things. First of all, that signature is yours. And secondly, that your statement that everything is true was done before you, the notary. It's official. Okay? The notary is not notarizing the information. He's only notarizing your statement that that information is correct. Now, a lot of times I've seen it come up. I used to be a notary, and I'm in process to get another certification. A lot of times it would come up where people weren't sure, you know, they had a document and they wanted it to be certified, and for some reason they couldn't certify it. And what I would tell them, well, certify it yourself. You can do that. You just go to a notary and ask for a jurat. So you have, under oath, which is acceptable to the state, have said this is a genuine document, that if the information is exact, either you're saying it's true or you're saying it's a true copy of an original paper. But it's your word that gives the paper now credibility when you swore before, or if not swear, you affirm that information. That's the job of the notary, okay? Another job of the notary is collecting bills for you. However, under California law, a notary can only do that if he's working for a financial institution. So we used to be able to do that. So not anymore. And on my website, I have at least half a dozen notary manuals going way back in history, so that if you want to know what the traditional job is, because those traditions are still good, even though they don't advertise it anymore. The notaries are not educated as to what their jobs are.
So you're saying if my bank has a notary, he can collect money from me?
The bank's notary is no different than any other notary.
I had to serve an affidavit, and they asked me to get it notarized on one sheet without doing the attachment. And I had to find a notary that would have the
no.
notarial notes on the first, so it was all on one page. But it was hard to find, but I
Well, it's okay to have one page, but then it has to be attached to the document that's part of that notarization process.
okay.
Yeah, you can't, you staple a document, better not remove that staple.
What is the legal definition of a financial institution?
First of all, I don't know. But secondly, it's probably an institution that has has articles of incorporation that says that their business is financial, and they're registered with the state.
So you could be maybe a check cashing business and you have a notary and they get to collect money possibly, maybe,
Well, that's a question.
yeah.
I couldn't answer that one, but
And when you say collect money, what do you mean?
can't hear you.
When you say collect money, what do you mean?
Oh, well, what notaries used to be able to do, and notaries who are parts of financial institutions can still do, is you could send a bill to somebody and tell them to pay it. You're a bill collector. And if they don't answer within a certain time or don't pay it, then the notary can send a second bill. The notary can send a second bill, and the notary keeps a record of his activities. They have a log. Anytime a notary does his official function, he has to enter it into the log, and he would enter that into the log. And so that creates a record. And so then, as time goes on, he sends out a third collection notice and certifies that no response was made. Now you have an enforceable record. You can take it to court. It's credible. That person is a deadbeat, okay? Whether it's a company or a human.
That can still be done today.
By financial institutions that have a notary, or the notary himself does it. Now, the notary that works for the financial institution, or any institution actually, whether it's a bank or a company, the notary is still an officer of the state, and the notary still can notarize things outside of the work environment unless there's a special condition, which is that when the person is working, the employer may require that the notary only notarize official business of the corporation, okay? But outside the corporation, a notary is still a state official and can notarize and charge the fees independently.
So, and when it gets to the notary sending the bill, is that they have to respond to the notary, or you could just go back and tell the notary that they still didn't pay on the third time? And
All the notary is doing is providing a credible record that the bill was sent and not paid. That's what it comes down to. So when you go to court, what's the court going to say? Well, what proof do you have that you sent the bill? Okay? Now, speaking of sending a bill, whenever you have a contention, don't send it by certified mail. Don't send it by registered mail. Okay, certified mail means that you don't trust the receiver and you want to be sure that they got it. Registered mail means you don't trust the post office, and they have to track every single step. They know who took it, who's responsible for it until it gets to the destination. Okay, that's the registered mail. Also, registered mail and certified mail are different in another way, but I haven't confirmed it. So I'm just saying this might be a possibility. But certified mail, I've heard is kind of like mail within the jurisdiction, whereas registered mail, you're outside the jurisdiction. Now, I don't know the subtleties of that, but
What about a firm book?
what's a firm book?
It's like you write in your book that you're sending something to somebody, and then the post office stamps in your book that you did in fact send it, but the person doesn't.
Oh.
Yeah.
Well, I'm not familiar with the term firm book, but I do know that you can get a receipt showing that you gave it to the post office. And there's a small charge for that.
Yeah, essentially that's what it is.
Now, the reason I say don't do any of that stuff is because when you mail, particularly we're talking legal papers, you provide to the court a proof of service or a proof of mailing, okay? That proof of mailing is somebody under penalty of perjury certifying that they put the document in an envelope, fully paid for the postage, and dropped it in the mail. And you dropped it in this city or in this county, whatever. That's your proof of service. So the court accepts this, and if the person truly did not get it, it is his responsibility to prove he did not get it. A little hard to prove a negative, but that's his responsibility. Maybe on checking, it turned out that the mail truck caught on fire, destroyed everything, and your mail happened to be on that truck. Now, I don't know how you'd find that out, but that would be adequate proof that you didn't get it. So, but the law presumes that if it was mailed, you got it. If you certify it, and he refuses to accept the certified mail, that actually becomes proof that he did not get it. Some storage people, you put your junk in a storage unit, right? And if that person, what they did is the storage unit sent certified mail, it was refused, and when they got to court, the defendant said, "No, I never got it." And there's the proof. The plaintiff had the proof in his own hands that he didn't get it. So now, if you send it, then the post office keeps a record, and you can get a copy of the record. Or if you're still a little insecure, you could have a return receipt, okay, a little green card that says that the person, and it can be signed or not signed. That is like the cherry on top, okay? It's nice to have the proof that they actually got it. But believe me, the basic presumption is, unless you think there's a risk otherwise, the basic presumption is if you got it mailed, it got delivered.
Can I ask one more question?
Oh my, of course.
There was like you said, if you were talking about the notary sending out 3 different bills.
Yeah.
And then the third one is actionable, I guess is what you're saying.
Yeah,
But then, so the fire department, they've got some arm of the fire department now that's coming out and saying you didn't do adequate brush clearing, therefore we're gonna fine you. And so they sent out this cute little Asian girl who came by and told me I was being fined by the fire department. And then they, so I said, I objected most strenuously to that, but they sent me one invoice that had never happened before. But, so they sent me one invoice that I was supposed to pay like $1,200 fine for which I did clear the brush, that's why I'm so pissed off. But, and then I had 30 days to appeal it, but I didn't appeal it. I meant to appeal it, but I got busy and didn't do it. But then they sent me they just sent me another, so I've gotten 2 bills from them. So, but they said I had 30 days to, but I could still challenge it because I haven't got 3 bills, is that correct?
Well, you can challenge it anyway, I think, because just recently there was a Supreme Court case which has not yet been resolved. It's just work in process. I think it was accepted for certiorari. But the Supreme Court is considering this, and the issue is the fact that the administrative process cannot force a collection. The only way to force a collection is through the courts. Okay? The court is a separate branch. So the administrative side, the governor's organization, they cannot do a taking of any property. And there's a big concern that if the Supreme Court says that that's an unlawful taking of property, that means whatever property was taken will have to be given back. And that could create a major problem for the government. On all
Should I cite that case and send it back to
Well, it's
them?
not a case yet.
Oh.
I mean, it's in process.
Oh,
All right, and the people that put this in, I think they went directly to the Supreme Court. So it's creating a little bit of a stir. I haven't seen the paperwork. I tried looking for it. I didn't push it. I mean, I could get it if I really pushed, but I have other things to do. But it's an interesting idea that, you can't take somebody's property without due process, and due process means court procedure.
so I could just say you're trying to take my property without due process?
Yeah.
You know, and then I appeal on that basis, or,
Yeah, and you know what they'll say. They say, oh, yeah, we can. We've got, here's a statute says we can do it.
that's not a law, though.
Well, no, statutes are equity rules,
Equity rule, yeah.
right? Codes are equity rules. Couldn't hear you. All right, now,
Not to beat this subject to death, but we have a comment by CyberGuys online on security. It says registered mail provides more security than certified mail. Registered mail includes tracking, insurance, and cage delivery. And certified mail only provides signature confirmation of delivery. I guess, is there agreement there?
absolutely.
Okay.
Registered mail is very secure because the mail gets locked up when the caretaker doesn't have it personally in his hands. They lock it up within the post office. And however, there are exceptions. And I happen to know this because one day I found a wallet. And I looked in it, and the identification was from somebody who was over on the East Coast. And I managed to track them down and say, hey, I found your wallet. And I'll send it to the address that's in there. They were happy. So I went to the post office, put it in, and they never got it. I later checked with them. They never received it. And yet I sent it by registered mail. Okay? So, and I didn't push the point, because basically driver's licenses are replaceable, credit cards are replaceable and so on, so. I didn't.
Which one is the green postcard that they just tear it off, once they deliver it, they tear it off, what is that called?
Receipt?
That's certified? But yeah, this green, the note without a signature.
Yeah, you can. Yeah, if you say without a signature, then that's exactly what they do. They deliver it in a normal fashion.
So it's certified without a signature. Or registered without a signature.
No, I'm not sure about registered documents if you can deliver it without registration.
Okay.
I mean, without signature.
Because I know there's one that you can send and then just a postcard you get back,
Look-
they received it.
No, you're getting into the micro details of their procedure, and I don't know them. Okay? But the general idea is that registered mail is very carefully handled within the post office. What happens, I don't know if you have the option to tell them to deliver it without signature. Maybe you do, maybe you don't. I know that is an option with certified mail.
I think the green card, that's return receipt.
Return receipt, that's.
Yeah.
Yeah,
And then you get return card to show that they got it.
So that's what we're supposed to do?
it's an option.
It's an option. That's the cherry on top.
Also, let me make a point with that. Sometimes you get the card returned.
Is that on?
Yeah, it's on. Hello? Yeah, okay.
Now it is.
Yeah. So this happened to me. I did not get a signature. I got it returned, or I did not get the return card. So what I did, there's a limit also. When you go to the post office and tell them, show them the receipt, you get your white receipt and tell them, I did not get, my green card. It's nearly 2 weeks, whatever. They will go in the computer and they will get a copy of that somebody did sign it. It's just it hasn't been returned to you for whatever reason. But the post office will give you a copy once you go to them with your white receipt, and they will give you a copy that was signed. Then eventually that green card will come to you. So I think they all work together, and once you go and you demand, then they send it to you.
Well, they are constantly upgrading their services, and now you can get a credible copy from the post office by way of the internet. You put in the numbers, they all have numbers assigned, and they'll show you a picture or whatever it is. They're always improving. So they're pretty good, I think.
You even get a daily email of what was delivered to your address. Literally.
Much technology
Yeah.
is privacy.
And I think Federal Express or United Parcel Service, when they deliver a package, they actually take a picture.
You do.
Yeah.
Amazon does also.
Yeah, so, modern technology is really progressing.
Also, there's a time limit. Happened with UPS with me. I asked them, they said, oh, we don't have that anymore. And it was like maybe a month or two. So yeah, time limit.
I like Federal Express. I had some medicine being delivered, and it was a multi-storied building. And when they tried to deliver it, it was rejected because nobody ever heard of the addressee. But the driver was talking to the wrong people. So I called up Federal Express almost instantly, immediately after he had left. And they radioed him and they got him to come back and deliver the package. I thought it was pretty impressive that they provided that service. So I didn't have to go, follow up any other way. Okay.
Another interesting tidbit, if you use the phone book from the U.S. Postal Service, when you fill it out in the phone book and you turn it into the Postal Service office, the postmaster has to handle whatever is filled out by that phone book. So it's considered delivered when you hand it off to the Postal Service, and it gets special handling.
Okay, yesterday we talked about yes, we did. We talked about definition of some words. And what was the word we were talking about? Oh, it was, why don't you, we were talking about calling somebody a customer as opposed to calling them a client, okay? So the word patient is owned by the doctors. The word client is owned by the attorneys, okay? And when somebody's your client, you are giving them advice and you can be held responsible for the advice you give. Well, there's another word, you got the same problem. It's the word record. Only a court of record keeps a record. An equity court does not keep records. Okay? Now, in their language, they get kind of sloppy and they talk about the record and so forth, but no, a record is very specific and belongs to a court of record. When you go to the clerk and you ask for a copy of the docket sheet, it has another name. Sometimes it's called an ROA. I'm going to misuse a word. It's a report of actions, I think, ROA. The first word is not quite right, but the O and the A stand for of actions. In other words, what did the court do? What papers were filed and so forth. But it is not called a record. Okay? So the report of actions or docket sheet, but not a record for the equity courts. So what a record is, a true record consists of only basically two things. It consists of what proposition was made to the court and what decision was made. Everything in between is not part of the record. Now, they may make notes, but the clerk might keep notes, but that's not part of the record. Okay? So the record's very narrow. Now, if you want to be a little more definitive, we can click on record in the part of the website where we talk about courts of record. And it says, the proceedings of the courts of common law are records, but every minute made by a clerk of a court for his own future guidance in making up his record is not a record. So that's one court decision. Here's another one. The common law record consists of the process, the pleadings, the verdict, and the judgment. After judgment, such errors were reviewable by writ of error, and so on. So you see, and here, when it refers to process, that does not mean what people said when they're in front of the judge. Okay? A transcript is not a record. Okay? The transcript is, just like it says, a transcript, what people said in the courtroom, but it is not a record. So, when I am dealing with the courts, what I do, when I make a complaint, I'm ready to go on it. I list in it what it is that I'm concerned about. You know, all papers basically boil down to they're either propositions made to the court and decisions, okay? So there's different kinds of proposals that you make to a court. For example, if it's your very first proposal, you might call it an action, or a declaration, or a complaint. Okay, different names for the first one. It's still a letter to the court, where you're saying to the court, this is what you want. This is what happened, and this is what you want from the court. So, just keep that in mind, that there are different names, but the whole process is basically, you make your proposal, like a complaint or a motion, the other side answers it, and then you have a chance to reply to the answer. After that, you make a decision. Somebody does.
Would that be the same as an affidavit?
An affidavit is a statement of facts. What is a fact? A fact is something that affects your senses. For example, hearing, seeing, smelling, tasting, and feeling. Okay? Those are your five senses. And then there's also what's going on in your brain, your state of your mind. Only you can testify as to what your state of mind is, okay? So those five senses, anything that affects that, if you saw somebody sign something or you saw somebody hit somebody, that's a fact because you saw it with your eyes, or you heard somebody yelling. Then you can testify that you heard somebody yelling. Those are all facts. Facts cease to be facts when they are accepted by the court. They change the name. Now it's called evidence. Evidence is a fact that got accepted by the court. And so you no longer talk about facts, you talk about evidence. The evidence shows, you've heard that statement a lot of time in movies, right? The evidence shows blah, blah, blah. So the facts are simply pre-court events or things that affect your senses. Okay, the tribune in ancient Rome was a magistrate whose special function was to protect the interest of the plebeian citizens from the patricians. Any defender of the people is a tribune. And so the tribune becomes the tribunal when he makes a decision. So we have a general definition. Remember, a court can be a tennis court. Okay. A space walled or marked off for playing a game, as in tennis or basketball. An open space enclosed by a building or buildings. Okay, but it's also, number 3, an assembly of the retinue of a sovereign. The retinue, that's the group of people that follow the king around wherever he travels. Okay. Now let's talk about orders. In order for an order to be an order, it has to be in writing, and it has to be signed, and it has to be filed with the clerk. Okay? That's what an order is. There was a case where somebody was in court and the judge made an oral decision. And so everybody went away from the court knowing what the result would be. The defending attorney received the order in the mail, and it was just the opposite of what he had heard. So, and it was written and it was filed with the clerk. So he appealed the case because, hey, this isn't what the judge said. Well, it turned out that what happened was the opposing attorney went back to the judge and convinced the judge to change the order. Okay? Well, that in itself is wrong because it was done without the presence of the other side. But still, the judge signed the new decision, filed it, and there it was. It was in order. And so the appellant lost.
There's no appealing that then, obviously.
Well, not that time. He tried, but the court said no. It was, and just because the judge said it, that's not a commitment. That is not a court order. Okay?
What should they have done in order to prevent that?
Well, we have in California and most other states something like what's in California. It's called the Council on Judicial Performance. And you complain to them, and if they get enough complaints against the judge, they'll figure out ways to get rid of him. Okay? When you make a complaint, that does not affect your case. Whatever it is. All you're doing is trying to get rid of the judge from public service. That's basically what you're doing when you complain. I suggest that any time a judge makes a decision, whether it's oral or otherwise, I suggest you do complain. Those complaints do build up. Of course, the people who are populating the Council on Judicial Performance, they mainly are attorneys themselves, or actually judges. Although I think it varies depending on which decade you're talking about. But when they have these panels, like the Council on Judicial Performance, or when they have civilian review panels for cops, they try to have a couple of civilians on there. Now, I don't know who the civilians are, but they had to have some sort of qualifications in order to sit on it, and it could be that they're not active attorneys. They may be retired or whatever. So, but that's what you do, you complain. Same thing with an opposing attorney. If he's a real jerk, complaining to the Bar Association.
Can you, when a judge makes a verbal order or decision, in court you can't say, let's have that in writing right now and enter it into the record?
Well, you could say it, and you could do it right now, but it's not an order till it does get in writing.
Right, but it's not, it is a procedure that can be done. So if you ever encounter a verbal order, you can say, let's get that in writing before we leave today and sign it.
You could do that. You could
So
say
that way you don't have to argue it later.
It's his discretion whether or not he does it.
Okay, but it can be done, okay.
Yeah. The bottom line is, you can do anything, but that doesn't necessarily mean you're going to get the results you want. Okay? Yeah.
And how can that not affect your case if you're complaining about the judge that's making the decision on your case, or you're complaining about the judge? You don't think that's going to persuade him to act a certain way?
I missed what it is that
If
you
you
asked me.
file a complaint on a judge that's dealing with your case,
Yeah.
you don't think that's going to affect?
Well, it affects future decisions because at the point you're complaining, the decision was already made, typically. Well, you might decide that you don't like him. Maybe he's a nasty judge. He's impolite, doesn't follow proper protocol or something like that.
And from your experience, that hasn't made him biased?
Well, my experience has been that I always get a letter back saying, well, we couldn't find anything wrong. Okay? But that doesn't mean you were ineffective, because they're very concerned about preserving judges' images. If they start, rubber stamping complaints against judges, that's going to take away from the credibility of judges. So they always say, oh, well, we didn't find it. We made a determination that everything's okay. All right? Well, but what really happens is that if there's a judge who's misbehaving, even though they're protecting the public image, they still might dump him. Okay? And you'll never know unless you look a few years later to see what happened. See, did he actually get dumped? So,
Can you ask to switch, as soon as you make that complaint, can you ask to switch judges?
no. All you're doing is complaining. It's up to them what they do with the complaint. Okay, but I can tell you that generally, the letter you get back will say that they found nothing wrong.
How hard is it to switch a judge?
Hmm?
How hard is it to switch a judge?
Oh, it's real easy. Before you get a decision from the judge, or before he at some point, there's a limit, okay? If you say you don't want the judge, you can get rid of him. Arbitrarily. You get one chance, okay? You've got one chance to recuse a judge, and that's it.
Before or during, it doesn't matter?
Whatever, it has to be before he makes a decision. Once he makes a decision, you can still recuse the judge, but you won't affect the decision. Okay? Now, having said that, if you have actual facts about the misbehavior of the judge, then you can recuse him for cause. That's different from having an arbitrary recusal. Okay? It's called a peremptory recusal, meaning that it's totally arbitrary, and you can do that once. You don't like the way he parts his hair, that's fine. You don't like him, so. But you only get one chance to do that. After that, you're stuck with whatever judge you have, unless you have an actual reason for getting him. A good example is that he has a financial interest in the outcome of the decision. Okay? A good reason is that before he became a judge, he was the attorney for the guy you're suing. Okay? Yeah, he'd be recused. That's for cause. Let's see. So I've now explained to you what a record is. Okay? Any questions? No questions. Okay, let's talk about minute orders. I talked about orders. Now let's talk about minute orders. Well, I already have to some degree, but here it is in detail. A minute is, in practice, a memorandum of what takes place in court, made by the authority of the court. From these minutes, the record is afterwards made up. Okay, so it's called a minute. It's actually, in that instance, I think the word is properly pronounced minute, because the clerk wrote it in a small hand, small writing. If it's an order, it's written in big writing. Now that we have typewriters and computers printing out stuff, they're all the same size. But in ancient times, before there were these machines for writing, that's what's the difference. It's either a large hand or a small hand, meaning a large writing or a small writing. Okay? And a minute is not considered as any part of the record. Okay? That is not the record. Just because you're reporting what's going on? Nope. Okay? And of course, a minute book means that the clerk is keeping a book, filling it in. There's a general principle that behind this. Any record, or I should say, to be technically correct, any writing that reports events, if it's kept on a regular basis, must be accepted as prima facie evidence and cannot be canceled out unless you have actual proof that the record is wrong. Okay? So, you keep a regular record of your daily activities. Now a question comes up, well, did you actually do that? Somebody questioned it? Well, yeah, I kept a regular record. IRS, you record your expenses. If you keep a regular record of your expenses, it must be accepted as valid, unless they have hard proof that you falsified the record. But as long as you keep a regular record, business records regularly kept, they must be accepted on its face. It's called prima facie evidence. Accepted on its face. Okay?
Well, regarding attorney and lawyer, can you say the difference between an attorney and a lawyer?
What is the difference between an attorney and a lawyer? Very simple. An attorney represents people. A lawyer knows the law. Those two are not necessarily the same. Okay? They have schooling that they're trying to make attorneys prima facie also lawyers. But there is a difference between a lawyer if you really drill into the meaning. Okay? Okay. think we got pretty much everything. Talk a little bit about court etiquette. When you're in court, there are some unwritten rules that you need to keep in mind. The most obvious one is when you go to court, they tell you to take your hat off if you're wearing a hat. That's been that way for 1,000 years, okay? Kind of comes from the time when people wore armor. When somebody's wearing armor and he meets someone else, he lifts his visor so you can see who he is. Is he friend or foe? If he's foe, he's not going to lift his visor, okay? But that's how you establish it. And that's the reason for saluting. When somebody does a salute, that comes from that custom, okay? When you are out in the public, or if you're in a hallway in a building, which is considered out in public, then you can wear your hat. When you go into a room, any room, then you take your hat off because you're in the room, that's the custom.
I'm sorry, to be in aviation, IFF, you have on the controller's radar, they see who you are. IFF is identification friend or foe. So that's just a little side comparison.
Yeah. Right, friend or foe. When you're saluting, you're saying you're a friend. Okay? And having done military service myself, sometimes I salute a person, even though he's a civilian. You know, it's a custom. And you dress decently. You don't go there in a bathing suit, okay? It's a formal process, and so you dress, California pretty much has disregarded that rule to some degree. You go to court, you see people dressed in all sorts of ways. The limitations are very simple, like the midriff can't be showing. Some courts have that rule. You have to have shoes, you can't go there in sandals. But they're not always enforced, but still, that's an unwritten custom. When I go to court, I always go there formally, in business suit. I have a shirt and tie, and I have a coat and slack. I try to look like a businessman. And that's the proper uniform. And when you go to court, you want to be careful about the symbols that you wear. You shouldn't go into court with religious symbols. You shouldn't go into court with club symbols, whatever they may be. The whole idea, of course, is that we want people to be generally neutral in their appearance. However, if you're wearing a tie is very customary. Okay, men wear ties, sometimes women wear ties, okay? You want to be sure that the stripes go in the right direction. So the way you can remember it is most people are right-handed and they wear the sword on the left side. So you're reaching across to pull the sword out if you're going to do battle, okay? Whoops. Let that be a warning. So, so you reach across to grab your sword. That line that goes there, that's called dexter, okay? If you have the stripe go the other way, that's called sinister. So this is, you'll see, for example, the no parking signs. You have the bar dexter. going this way on a no parking sign. You have that circle with the line, and it has the letter P, meaning no parking. So the bar dexter means, you'll see it, it's in that direction. That's an order from the sovereign, okay? That is a sign that you're part of the nobility, okay? If you see it going the other way, then you're the common people, okay? In the 1970s, up until the 1970s, ties were pretty much all bar dexter, all this way, going from your upper right to your lower left. And that goes back to when we declared our independence from England in 1776. And because when we declared our independence, we dumped the nobility and everybody became sovereign. The people are sovereign, right? And so the ties, the way we dress, or the clothing that we wore, if they had an angular bar, they were always the bar dexter because we were sovereigns. Then I noticed that around 1970 or so, right in there, one of those decades, they started producing ties with the bar dexter, but also neutral ties. And eventually, for about 10 years, they were pretty much all neutral ties. And then afterwards, I noticed that they started producing ties with the bar sinister. What are they doing? I also noticed that more frequently, I was hearing on the radio English accents. People had English accents. They were announcers. They didn't have the normal local accent. I noticed that. And I also noticed that they were kind of changing things. For example, when you went to school in the 50s, you had your grade school, you had your junior high school, and you had the high school. Well, the most significant there now, they don't call it junior high school anymore. They call it middle school, which is very much European. So what are they doing? Well, I had noticed, well, I actually read where somebody of significance had said that they really wanted to go back to the old feudal system. It worked well for the powers that be, okay? And so Europe was closer to the feudal system than the United States was. So little by little, the powers that be are trying to twist our society toward the European system, and they really want to go back to the feudal system, you know? So take note. So in a court of in a court, you have these unwritten rules, and we generally conform to them. You know, like I said, when I go in the court, my tie always has the bar dexter, always. Now, is that significant? Probably not. But here's what I do know. If the judge understands that, and judges aren't necessarily stupid, okay? If he understands that, and you walk in with a bar sinister, and he sees it, he knows you don't know. If you walk in with a bar dexter, then he doesn't know if you know or don't know, okay? No point in bragging about your innocence or your ignorance, okay? We got smoke coming into the room. Is the door open? A little bit? It's coming over into this corner. I can smell it real strong. No, it's not It's not objectionable, I'm just saying, I notice it's, no, I'm just noticing it's building up, you know?
Yeah, before we pass out, better say something.
Yeah, detail, yeah.
Yeah. Bill, should we take a break?
Well,
We've been going for 2 hours.
What?
We've been going for a little more than 2 hours.
That's it?
2 hours and 15 minutes.
court is adjourned for 10 minutes.
Court is in recess.
In recess, right.